me that he supports adoption of the report. Carol Hobbs-Picciotto is required by her duties to be absent today. Jason Koulakis to my left, Jackie Bernard to my nearer left, and the Honorable Arthur Grimm was on his way from Berks County this morning and was turned back by the weather. Being the dedicated jurist that he is, he has a court session. He was able to get free this morning and wanted to be with us. Is obliged to be in court this afternoon, and I think quite accurately assessed the weather situation and determined that it was necessary for him to go back so that he could perform his duties in court. He, of course, has been very much involved in the ongoing deliberations, and I think it's fair to say that he supports the adoption of this report. Before we go any further, let me say that this has been a great experience for me. The folks who are present this morning have put in more hours than anything I've been a part of in state government, have committed enormous effort. It is perhaps understandable that they would. We have two doctors who on opposite ends of the state have confronted on a daily basis the consequences of child abuse. We have a prosecutor who has fought in court to deal with those responsible for child abuse. We have a solicitor who went into the list, both advised children and youth personnel, but went into the lists to fight those who abuse children. We have a dedicated person who for years and years has served the victims of violence. And we have, as I guess our designated member, I always get this confused, but at any rate, our Deputy Secretary, who of course has committed the best part of her life to fighting child abuse on a variety of fronts. So it's not surprising that there would be commitment, that there would be arguing about fine points of law. Sometimes the doctors turn out to be more lawyers than the lawyers. But this has represented, I believe, an enormous challenge to the folks from Joint State. And I want to say I was assured this morning that we are the worst group they have ever had to deal with. And I believe that to be true, and frankly only compounded by a chairman who's just an eternal optimist, and I'm just sure everything's going to get done and we'll get there, and would rather hear debate than try and cut it off. And so when I saw, I think at one point yesterday on my iPhone, up to 50 emails, I knew that we were really cooking. And this I cannot express adequately my respect for this group who, through to the end, has fought to make it right, and not fought with each other. I mean, there has been a remarkable level of mutual respect and bonhomie, but at the same time a commitment to get it right, right down to the point where Jackie Bernard noted that there were some things that we had voted upon that got missed, and so we're going to need to deal with that by an amendment this morning. All of this is not the way Joint State likes to work, and I would like to join with my fellows in giving you folks a standing ovation. Of course, there's been a great deal of terrific staff work beyond joint state. We addressed that in the report, but I know we have been a sore trial to you. The good thing about today is you'll be rid of us shortly, well, without further ado, I think that the floor is now open on the question of whether, after all this, we adopt this report or just ask the legislature to re-up us for another year.
Mr. Chair, first of all, thank you for your dedication and leadership in convening all the numerous meetings and presenting some of the best stakeholders statewide to educate us and help us through this incredible Herculean task. I thank you personally for that. And with that said, Mr. Chair, I would respectfully move that this task force adopt the report as presented.
Is there a second? The report be adopted. Are there any amendments?
Mr. Chair, I have two amendments. These are both matters which we discussed at length and unanimously adopted by majority vote. The first is that we have agreed that we need to afford children in Pennsylvania the same protections that many people in protected classes receive pursuant to the aggravated assault statute. And the language will be included in the report. And thereby also increase penalties for crimes committed against children where bodily or serious bodily injury is suffered. The second amendment deals with child pornography, which in Pennsylvania is known as sexual abuse of children. And the amendment that we have unanimously adopted is asking the Pennsylvania Commission on Sentencing to examine and increase the sentencing penalties for sexual abuse of children, taking into account such matters as the number of images, the age of the children, the types of activities that these children are required to engage in, and therefore afford children additional protection in the Commonwealth of Pennsylvania.
Is there a second for those amendments?
Mr. Chairman, I second that motion.
Thank you. I will make the observation that it is my recollection that both of these matters were discussed and known both to those who are present and those who are not present, and the omission is simply an oversight. Is there any discussion?
Mr. Chair, your mic is not on.
Oh, thank you. Is there, at any rate, I believe this does not come as a shock to anybody, but is part of what has already been discussed. Is there any discussion on the amendment? Then I will call for a vote. All those in favor of the inclusion of the two amendments described by Ms. Bernard in the report, please say aye.
Aye.
Any nays? I hear none. So the report is now amended. Is there any discussion on the question of the adoption of the report? Hearing none, I will call for a vote. All those in favor of adopting the report as amended, as the report of this task force, which of course is the charge which we were given by the General Assembly, all those in favor, please say aye. Aye. Any opposed? Any abstentions? Then of those who are present, it is unanimous. And our purpose as a task force is concluded, and with my thanks and gratitude to all who were involved in this endeavor, I would, well, I guess we should be democratic. Is there a motion to adjourn? Nobody. Okay. Nobody wants to. Yvonne, I will exercise the privilege of the chair. Yes, you may.
Mr. Chair.
Hey, no. Fair enough.
I will make the motion to adjourn the business aspect of this meeting.
Oh, absolutely. Oh, there's more to come. But the meeting itself is by unanimous consent adjourned. And now we move on. We have, of course, quite a full group of folks today because of the hell and torment we've put the folks from Joint State through. It is my understanding that by this evening, the full text of the report, including the amendment, will be available on line at, among other places, www.childprotection.state.pa.us. Any other locations? That would be where it'll be? Okay. So this, for those who are, if there are those who are listening out there in the ether, www.childprotection, all one word, .state.pa.us. And of course, bound paper volumes of the report will be forthcoming shortly, at least if our folks from Joint State don't run screaming out into the night and refuse to come back for a week or two. We all will be making some comments. Let me suggest that when you get a copy of this report, addressing myself to the press in particular, but also to those in the legislature, others who will be considering this, I wrote a letter in the beginning of the report, and it expressed a number of the things I would like to stress today. One of them is that we were charged, I believe, to put children first, and we endeavored very, very hard to do that. Now, that means, to some degree, recognizing that if we over-recommend, if we bury the system, children will suffer, and the point was made very tellingly, I believe, by Bob Swartz early on, the kids who will most suffer by a system that is unrealistically burdened are those most in need. So we've attempted to be bold, to leave no stone unturned, but also to be realistic. In being realistic and at the same time idealistic, we were given this task, you know, we run out in 2 or 3 days and it's done. So we tried, and you have a wonderful group of experts here, excluding myself, we tried to do the very best we could to improve a system that is woefully failing in a number of ways today. We get one crack at it. It doesn't mean that it is realistic to say in 6 months' time this is all going to be fixed. Obviously, the Sandusky scandal, the scandal in the Archdiocese of Philadelphia and the prosecutions arising from them give rise to what we're doing, I suspect, if you can read the minds of the legislature. What we did here is not a knee-jerk reaction to anything. It is a seizing of the opportunity to look at the whole system, to have, two of the foremost doctors in this field look at what we're doing, to have experienced prosecutors, lawyers who know the system, advocates, others, jurists, look at the system and say, how do we make this better? And then go ahead and try and lay it out as best we can. I am really tickled. We heard from a number of wonderful advocates. As I look down, I guess Kathy Palm, I'm told, can't be here today. Oh, she is here. There you go. Thank you. You recently gave us a list of 16 things that should be a starting point for measurable reform. I believe, and I haven't looked at this in a little bit, I think aside from recommending the establishment of an ombudsman, I think we've hit every one of your 16 points. And I am just enormously proud of what we've done, but realistically, it's going to take time to implement. We'll get to some of that in a minute or later, but it is important above anything else, and this is almost a charge to you, ladies and gentlemen of the media. I'm sure there'll be legislation passed, you would hope within 6 months or so, but the real issue is come back in 9 months, a year, 2 years, 3 years. This needs to be an ongoing process. The resources, one hopes, will become available over time to do much of what we recommend. Some of it we think we can get done for free, but this is a long-term proposition. Now, enough generalized blather. Let me ask some of the members of the task force to talk about some of the specific things we recommend. And Dr. Christian, eminent physician, pretty good part-time lawyer, would you please address the issue of child abuse?
Thank you, Mr. Chairman. First, let me say that it's been a pleasure to not only work with you on this task force, but even to carpool with you back and forth, saving the taxpayers just a few dollars every trip we took. My name is Cindy Christian, and I am a pediatrician, and specifically a child abuse pediatrician. I've been working at the Children's Hospital of Philadelphia for more than 28 years, and in most of those years still run the program that deals with victims on a daily basis who are abused and physically abused, sexually abused, terribly neglected by their children. For the last few years, I've also worked part-time as the first medical director for the Department of Human Services in Philadelphia. So I know child abuse from both a practical point of view, and I also understand it from the child welfare point of view. And finally, I'm a professor of pediatrics at the University of Pennsylvania and a faculty director of the Field Center. I have personally felt incredibly honored to have been appointed as a member of this task force. It has been a great privilege for me to work with my colleagues who are on the task force, some of whom are old friends, some of whom are new friends. And I really want to assure everybody that we have worked diligently to improve our collective response to child abuse in the state of Pennsylvania. As I think all of you know, we come from different areas of expertise, and I also want to stress that at times we had very different points of view. But we worked through our differences to come up with recommendations that I think, as my motto, we say, are for the protection of children and not for the convenience of adults. Okay, so we really worked hard to do our work to help kids. I've been asked specifically to summarize our recommended changes to the state definitions of child abuse. And for those of you who don't do work in this area every day, you might think, oh, like, what's so difficult about defining child abuse? I know an abused child when I see an abused child, but sometimes what I recognize and know to be child abuse does not meet the Pennsylvania state definitions of child abuse, because a child before me may have multiple bruises all over his body, but he may be running around playing in the playroom at the hospital, and he may not be in severe pain, and he doesn't have any dysfunction to any organ in his body, and he might not meet the state's definition of child abuse. I may see a baby who has been on multiple occasions suffocated by a parent, but when a pillow is pulled off the baby's face, the baby's breathing, and the baby comes to the hospital and doesn't have any injuries, that child might not meet our state definition of child abuse. So one of the things that some of you might believe is that our work really addressed the issues of sexual abuse in the state, and we took a much broader approach. And in terms of our definitions, although we've made some minor adjustments to our recommended definitions of sexual abuse, for the most part, in Pennsylvania, our state laws define sexual abuse in an appropriate way. Where we made some significant and major recommendations is in the area of child physical abuse. Those definitions have been incredibly problematic, and there was not one person who testified before us or who submitted written testimony who said that our definitions of physical abuse were exemplary or even satisfactory. We heard repeatedly, over and over again, that the definition of physical abuse is vague, it's open to interpretation, and it's very narrowly defined so that we cannot protect children who need to be protected. So presently, the state definition of child abuse reads as any recent act or failure to act by a perpetrator which causes non-accidental, serious physical injury to a child under 18 years of age. The meaning of non-accidental is difficult. People interpret it in different ways, and the ways that the court interprets it is not always the ways that a doctor, for example, or a child welfare worker might interpret it. The definition of serious physical injury requires presently that a child sustain severe pain or impairment of physical function, but I just gave you examples where a child may not have severe pain or impairment of physical function. So we recommend changing the definition of child abuse to include recent, intentional, or reckless acts, attempts to act, and failures to act that cause or create a reasonable likelihood of bodily injury or serious bodily injury to a child. These definitions mirror criminal law definitions of simple and aggravated assault. But in addition, we recognize that there are certain intentional or reckless conducts towards a child that should be considered abuse, and we are making these recommendations that they are considered abuse regardless of the resultant injury. And these include kicking, burning, biting, stabbing, cutting, throwing, or unreasonably confining or restraining a child, forcibly shaking or slapping an infant, intentionally interfering with a child's breathing, causing a child to be present where illegal drugs are manufactured, such as methamphetamine labs, and driving under the influence of alcohol or drugs with a child in the car. In our definition section, we have eliminated non-accidental from the definition. We've eliminated the need to show severe pain or impairment of physical function. We eliminated the differentiation of student abuse from the definitions of child abuse. And we also recognize that at the end of the day, after an investigation is done, regardless of whether we can identify the identity of a perpetrator, if a child has injuries that are clearly from abuse, that we recognize and count that child as being abused. Because presently, if you don't know who the perpetrator is, that report will not be an indicated case of child abuse. We need to recognize that regardless of whether we know who did it, we still identify that child as being a victim of abuse. I'm happy to take any questions later. And again, thank you very much for the time, Mr. Chairman.
Thank you, Doctor. And I believe for those of you who aren't great note takers, I think a board just arrived that should contain the definition of abuse that Dr. Christian has just been describing. I next would call on. Is it on? I next, thank you, would call on Dr. Berger to elucidate I think you have a variety of subjects to cover. Doctor, the floor is yours.
All right. Thank you, Mr. Heckler. So first, again, I'd like to thank the other members of this committee. This has been an unbelievable group to work with. The hours and hours of meetings, I've really gotten to know all of them, and I'm really honored to have served with them. This committee has also given me the opportunity to listen to every single book on tape that the Carnegie Library has in my 400-mile drives every time we met. I also like to thank Children's Hospital of Pittsburgh for giving me the time to do this, and to Mr. Scarnati for appointing me to this committee. In way of background, I'm a pediatrician. I've practiced for more than 15 years in the state of Pennsylvania. I previously was a primary care physician, and now I'm a child abuse physician, and as part of the child protection team at Children's Hospital for about the last 11 years. I was asked to briefly talk about 4 issues, each of which we could discuss for hours, so this is really a very, very brief summary. The 4 problems, and I'm going to talk about the problem and then the solution, are Childline, General Protective Services tracking, information sharing, and Child Protective Services workers training. The first of those issues is Childline. As you know, this is the number that we call when we have a concern of abuse. To give you some sense, there are over 140,000 calls a year to Childline. About 69,000 of those are for child abuse. That is a tremendous number of phone calls that we're talking about. This really is probably one of the most important parts of our CPS system. If the initial call is either not taken, and I'm going to talk about that, or something is done improperly, the system itself can no longer function, and the public confidence in the system is no longer there. So the testimony to the task force has identified a lot of very specific problems, and I'm going to touch on those and their solutions. In terms of staffing, we heard a testimony about the fact that there's almost always vacancies, that these are hard positions to fill. They are full-time only positions. They often require a lot of overtime. The number of dropped calls in 2011 was 8.7%, meaning that percent of people called and hung up before the call was ever taken. It doesn't mean that they didn't call back, but we don't know how many of those calls where children needed to be protected. And there have also been very long holds at some points. So we've made several suggestions to address these. We've asked to explore the possibility of part-time work. There are many former and active Child Protective Services workers who have a tremendous amount of experience, who could staff, it doesn't have to physically be at Childline, who could help staff this and provide additional coverage. And so that, I said, hopefully that will help. We need to keep this fully staffed at all times, and we're likely going to need to have more workers at Childline given some of the other recommendations that I'm going to discuss. The second one is an inefficiency with the Childline system. Most people don't realize this. At this point, it is all paper. Somebody takes the call, they write it down on a paper, they pick up the telephone, they call the child protective person, and they tell them the same thing. It's like telephone tag. And then they take the report, they put it in an envelope, send it by U.S. mail to the police. There is almost no other system in this country that still works with this paper system, where essentially it is a game of telephone, because each person is now calling somebody else. Clearly this is inefficient, but also there's room for inaccuracy. So one of our suggestions is to allow for electronic transmission of reports, both from the mandated reporter to Childline and from Childline to the police and to the local CPS, which means if it's electronic, they don't need to sit on the phone and rehash what they've just heard, and the police will get the information immediately. The next issue that I was asked to talk about was GPS tracking. This is General Protective Services. As many of you know, we have a differential response in Pennsylvania. We have GPS, which is General Protective Services, and CPS, which is Child Protective Services. Traditionally, Childline CPS calls went to Childline, GPS calls went to the county. Historically, people have thought of GPS as less severe, not as important, and to have children at lower risk. The data shows us that this isn't true. We've heard testimony from multiple people that GPS may actually, those children may actually be at higher risk. When people have looked at subsequent reports within 18 months of an initial GPS, the rate of re-abuse may actually be even higher than children with CPS reports. And in fact, some of the most publicized case recently, a death in Philadelphia, were children who had multiple GPS level reports. GPS also in large part is about patterns. And so if the counties are each individually collecting information, a child moves from one county to another, there is no way to know that that child has been in a different county. So one of our suggestions is that all calls go to Childline, whether it's a GPS or a CPS. Every single call is ultimately tracked by Childline. People can still call their local counties, but then the counties will need to call those calls or electronically transmit the calls to Childline. All of them will be tracked. Currently, we have no way to track our GPS cases, so we really don't have a good sense of how many children are even being served or in the system, or how many repeat calls we have in different counties. So we are suggesting that all calls be tracked and everything be tracked at the level of the state, and that they are tracked by both child and perpetrator. So if there's a perpetrator in multiple counties and there's multiple reports, there will now be a way to link that there are the same perpetrator in multiple counties. Similarly, if the same child is a subject of 5 or 6 reports, that clearly represents a different level of risk. The other thing is, currently all reports that are not indicated are expunged at 15 months after the report, so you have no record that that report ever existed. We're recommending that there is no expungement of reports. It will not be released after a certain amount of time, but the data will exist. So even after 15 months, we can link perpetrators and children. And as we saw with Sandusky, it was many, many years between different reports. So this will help to link those different cases over time. Again, this information is not going to be released, but it will be available to help with the safety of children. The third issue is information sharing. We've had multiple people testify, and I know from my own experience that lack of information sharing is a very important problem. Children's pediatricians or their primary care providers really serve as the safety net for young children in our society. There is often no other person outside the family who sees a child who's 3 months old, 6 months old, 9 months old, except their pediatrician. Once kids are in school, the school acts as their safety net. So the only non-family with constant contact may be that child's pediatrician. We would like to move toward a system where Child Protective Services and the medical profession, and particularly primary care physicians, are a team that are caring for the child, and there's a free flow of information. So we're recommending very explicitly that there is no parental consent required for the PCP to talk to CYF or vice versa, and that HIPAA, although HIPAA does not apply in cases of child abuse, we are going to explicitly state that so that there cannot be a misinterpretation of the meaning of free flow of information in cases of child abuse. CPS, we're also asking that CPS be allowed to contact the PCP whenever they are involved in a child's life and providing services. One of our people that testified stated that about 40% of her children at any one time were getting services from CPS, and she had no idea which ones of those patients were getting services. So we need open communication. And again, this is what's the best for children in our system. Finally, I was asked to talk about Child Protective Services worker training. In the report, there is a quote from Richard Gellis, which I think summarizes what the issue is. He says, "Protecting children from abuse and neglect is not brain surgery. It is much harder. Brain surgeons have the advantage of a decade of specialized training and the use of the latest and most advanced technology. Frontline CPS workers have only a bachelor's degree in the liberal arts and a job tenure of 3 to 5 years, which actually for some counties is very long. We have some counties where the average tenure is under a year. The latest technology in CPS is a cell phone, and if budget allows, a laptop. And I often say to people, we send our police officers out 2 in a car with guns, and we send our CPS workers by themselves with a cell phone. The CPS worker should be the center of the CYF system, and we need to support them and train them and make it something like Teach for America, where people want to do it and want to help children. So our solutions or suggestions to support our CPS workers much more. Information sharing will help them to be part of a team so they work with other people in other systems. We're recommending to review and analyze how we hire and retain CPS workers. Feeling supported is a critical role for not being burned out, and we need to explore how we can do that for the CPS workers. And we need to enhance supervision. Just because you get promoted from a caseworker to a supervisor does not mean you have the skill set to act as a supervisor. And we need to help train those supervisors so they can truly supervise our CPS workers. So those are the 4 in a nutshell issues that I was asked to address, and I can answer any questions at the end.
Thank you, Doctor. I would next call upon Jason Koudelakis to describe some of the recommendations we make with regard to perpetrator mandated reporters. I didn't know much about the CPS side of things when I began this assignment, and when I learned that obvious abuse to an infant, horrible injury, might not be called abuse because either we couldn't figure out exactly who the perpetrator was, there might be multiple perpetrators, or the person didn't fall within a particular category which would make them a perpetrator. So for the purposes of statute, child abuse didn't exist. I thought my head would explode. Jason is going to offer some reasons why hopefully other people's heads won't explode in the future.
Thank you, Mr. Chair. Again, thank you for the opportunity to be a part of this wonderful team. Thank you to Speaker Sam Smith, who is an incredible child advocate, and he was the one that nominated me for this position. I thank him. I also want to thank those that are line workers that, while the system has problems today, they are really heroes. They are the front line to child advocacy, folks like the state troopers that are here with us today, and my good friend Sean McCormick, who's a prosecutor here in Dauphin County, who's in the back, daily fight for children who are victims of horrible crimes. So I personally thank them. The current definition of perpetrator, as our chairman has indicated, provided lots of loopholes in some of the high-profile cases that we've experienced in Pennsylvania in the last several years. Currently, perpetrator is defined as somebody that has a special relationship with the victim child, a parent, a person responsible for the welfare of the child, and that's further defined, someone over the age of 14 residing in the home, or a paramour of the child's parent. The task force believed it was necessary to revisit that definition, and we have greatly proposed expanding the definition in order to, as we begin today's conference, putting children first. And so we thought it was necessary to do that by expanding and properly defining who a perpetrator may be. And it's important to understand when we're talking about the definition of perpetrator, we're talking about the definition within the Child Protective Services law, not in the Crimes Code. In Pennsylvania, we have two distinct parallel systems. The Crimes Code most people are familiar with. We have law enforcement and prosecutors that are primarily responsible for effectively disposing of victims' crimes in Pennsylvania. But we have child welfare workers that are primarily responsible for investigating child abuse as defined by the Child Protective Services law. This report that is being presented today expands the definition of perpetrator by adding a spouse, a former spouse of the parent, former paramours, extended family not living in the home, for instance, a visiting relative, any person over the age of 14 who is present in the child's home. And the idea is, again, we want to put children first, and the home should be a safe haven. So we want to make sure that any time there's some sort of incident in the child's home, that we capture that incident and we protect that child. We additionally added the definition just beyond, not to include just the residence, but also the curtilage, and everybody laughed when we suggested the word curtilage. But Pennsylvania is a very diverse state, and there are lots of areas outside the residence proper where horrible things happen to children. And we need to make sure, again, children are first, and if they're in their safe haven, we capture those individuals. Persons responsible for the child welfare has also been broadened to include any person who, through a profession, employment, volunteer activity, has access to children on a regular basis and is in a relationship of trust, such as a coach, instructor, leader, mentor, chaperone, or other role in a program, activity, or service in which children participate. This was a direct response to the mandate given by the General Assembly to first deal with the overarching concerns that what happened with the Penn State debacle. I think that the task force has done an outstanding job to ensure children in all settings where someone has left their child with another individual in a trusting position, we will be able to make sure we keep those children safe. Mr. Chair, I've also been asked to present on another topic that was within our charge, and that is mandated reporters. Another very important area that gave rise to some exposure in the media in the last several years. It's incredibly important that everyone knows that they can report child abuse. In fact, we say all persons are encouraged to report child abuse if you observe something you reasonably suspect is child abuse. It's important to know the primary way to do that is through Childline. And there's a toll-free number. I want to make sure that the media puts this in the articles that are put out today. It's 1-800-932-0313. 1-800-932-0313. But there are those persons that, because of their employment and relationship to children, are required to report suspected child abuse. This report clarifies several things. First, that the victim child, need not come before the mandated reporter in order for that person to make a report. It also provides, as Dr. Christian pointed out, it's not necessary for that mandated reporter to conduct some sort of investigation to identify who committed child abuse. What's necessary is that the mandated reporter have a reasonable suspicion based upon their education and training to suspect that the child has been abused. Once that mandated reporter has that information, they are compelled to make the report. The task force additionally expanded those persons beyond who are currently required to report to the following. Any individual who accepts responsibility for a child in a program, activity, or service. Social service workers, law enforcement, attorneys, public librarians, emergency medical service providers, and that's further defined. Film processors. Why? Lots of times young children have their images taken and preserved. IT repair and service personnel for similar reasons. All employees are independent contractors of other mandated reporters. This is done in direct response, again, to the two high-profile cases we experienced in Pennsylvania in the last several years. Additionally, the task force recommends that if a child makes a specific disclosure that they have been the subject of abuse, or is aware that another child has been the victim of abuse, and that information is provided to the mandated reporter, that mandated reporter must also report that incident. Under current law, if a child is abused in an institutional setting, reports are permitted to go up the chain of command. We saw that at Penn State. There was supposed to be the report up through the designated individual, in this case, Graham Spanier. This has been changed in these amendments to require the person, the individual, who discovers the abuse to report it immediately to Childline. Notification to the individual reporter's supervisor or other person in charge of the institution is also required. This builds in redundancy, again, putting children first and making sure we're capturing these incidents of child abuse. As also was indicated, I think, by Dr. Christian, the role of school employees. Currently, under the Child Protective Services Law, there's a carve-out, as I call it, where school employees are treated differently. They have different definitions and different rules. This task force, in its recommendation, has indicated they believe that there should be no carve-out. There's no reason to treat employees of schools any differently than any other individual. One last point as far as mandated reporters goes. Currently, infants that are born drug positive are required to be brought to the attention through medical personnel to the County Child Welfare Agency. In addition to that, this task force is recommending that county child welfare agencies must put hands on that child within 24 hours and actually see the child, rather, in 48 hours to assess safety and risk of that child. That does not mean it's child abuse, but again, we're putting children first. Mr. Chair, I think that concludes my presentation.
Thank you very much, Mr. Koulakis. Certainly been one of the most provocative members of this task force in terms of fighting for what you believed, and this product is much the better for your role. Let me just point out, I'm sure a number of you have figured it out, but one of the things to add to what Mr. Koulakis has said about mandated reporters, in addition to expanding who they are, we propose to better train them, and as a part of that training or their licensure where they hold some sort of state license, they will be required to complete an oath. And I can tell you, I would hope that this will be enacted, and that at least in Bucks County, I can tell you that if they violate their oath and don't report child abuse and are prosecuted, C1 is going to be the oath that they signed and then broke. There is going to be no ambiguity about who's a mandated reporter and what their responsibilities are as mandated reporters. One of the tougher areas, at least for me to get my arms around, is the smart part, and that would be natural, being who I am. I always try and do things the hard, dumb way. But obviously, I guess it was Benjamin Franklin pointed out that a stitch in time saves 9. And I'm next going to call on Delilah Rumberg with Pennsylvania Coalition Against Rape, who has been a consistent voice throughout our deliberations for prevention, for finding ways to prevent kids from being victimized to begin with, which I have to admit is the smarter way to go if you can. Delilah?
Thank you, Mr. Chairman. And I appreciate the opportunity, and I'm honored to work with this group. And my role was that of representing victim services, and particularly programs that work with children who have been victims of child sexual abuse. There's been a network of victim services in this Commonwealth for 40 years now, and funding was available back in the late 70s and early 80s to provide for victim services. However, in the last 12 to 15 years, many of us in the victim service field have really begun to shift our focus, while continuing to provide services, of course, toward prevention and primary prevention. And it's unfortunate, though, that this Commonwealth still has not provided funding for that prevention efforts, and that's what one of my biggest pushes have been all along. We've got to fund prevention. Evidence-based prevention programs should be encouraged and financially supported where feasible. There are numerous models of successful prevention programs, not only here in the Commonwealth, but throughout the nation, and we really need to start considering those to determine whether or not they're adaptable to the diverse communities that we have throughout the Commonwealth. And again, I would call on the legislature to make this a priority. Prevention efforts, as you indicated, are less costly than trying to fix things after the abuse has happened. The task force acknowledged that a child should be protected after the child abuse or neglect has been alleged, and the child and the child's family should receive appropriate services, and the individual responsible for child abuse or neglect should be appropriately identified and punished. However, prevention should be an equally important, if not greater, component regarding child protective services and general protective services. Therefore, the task force recognizes the importance of working with children and their families who have been entrusted, or those who have been entrusted to care or supervise for them, so that nothing ever happens to begin with. The task force supports the use of evidence-based prevention programs. Effective early prevention efforts have been proven, as I said, to be much less costly than trying to fix things later. The protective factors approach has been recognized as one of the most promising in the area of child maltreatment prevention, and its effective application requires more than individual practice and program changes. The Strengthening Families Initiative of the Center for the Study of Social Policy has identified 3 areas for change. The impetus for more programs to take on protective factors approach includes parent partnerships to ensure that prevention strategies are responsive to family needs and choices, professional development to train individuals who work with children and families to develop common knowledge, goals, and language, and policy and systems to develop regulations and procedures that create broad and sustainable change. The public health model has been one that we've been embracing for the last, like I said, 10 to 12 years, and it's widely used in developing prevention programs across the country, and it classifies prevention in 3 different areas: primary, secondary, and tertiary. The main component of primary prevention of child sexual abuse specifically are teaching people about healthy relationships, identifying a situation that could become abusive, and protective policies that may be implemented. Secondly, we need to teach people what to do if they suspect the risk of child sexual abuse. And thirdly, we need to work to change social structures and norms that actually support the occurrence of child sexual abuse. Secondary prevention includes teaching people who are responders, possible responders such as doctors, teachers, and parents, how to screen for child sexual abuse and what to do if they suspect it. Secondly, we need to increase awareness about social services that are available to the abuse survivors. And third, we have to reduce the stigma that is associated with child sexual abuse. Tertiary prevention of child sexual abuse consists of preventing further harm to a person who's already involved in an incident. The 2 chief components are working with perpetrators to prevent them from reoffending, and working with victims to prevent long-term problems. The social ecological model of sexual abuse prevention examines multiple systems that surround an act of violence. It emphasizes the idea that child sexual abuse prevention and other types of violence prevention requires changing norms, climate, and culture. Therefore, it addresses how we can promote both community change and individual behavior change. There are several types of programs that are available to engage adults in preventing child sexual abuse. It is every adult's responsibility to protect a child. Components of school-based programs to train teachers who will be instructing children and education orientation sessions for parents and guardians. Standalone parent education programs, training for professionals who are mandated reporters, as we've indicated earlier. Public education campaigns are also critical in addressing the broader audiences and raising awareness about the problem and assisting the public in identifying the signs of child abuse. Lastly, media campaigns and social marketing campaigns that draw upon research and behavior change theory to develop these strategies. Again, it is the Commonwealth's responsibility to invest in prevention so that no child is ever abused. Again, I thank my colleagues for putting up with my consistent, what about prevention? I felt that was my role because we had those that were professionals in the law and in the medical field, and I just was really so impressed with their ability to include the prevention effort in all of those different models. So I thank you very much.
Thank you. The next presenter will be my fellow prosecutor, Jackie Bernard, who will talk about some of the things we propose with regard to the criminal justice system.
I can still say good morning because it's 5 till 12. So good morning, and thank you all for coming. To the members of the press who are here to disseminate our recommendations and really raise the awareness of the public as to this issue of child abuse. and many familiar faces, people who have testified before us. Thank you for following us and seeing what the recommendations are. My name is Jackie Bernard, and I'm a Blair County prosecutor. I've been a prosecutor for 17 years. I started out as a child abuse prosecutor, and that's what I did 24 hours a day, 7 days a week for 3 years straight. I didn't have one holiday during that 3 years when I wasn't called out to handle a child abuse case, which is very sad commentary on the state in which we find ourselves. I am humbled and grateful to be here and to be part of this group. I too want to thank Speaker Smith for nominating me, and the Senate and the Governor and the House for approving my participation with this group of very talented people. I think we all believe that we are here to serve the children. Yes, we're here to make recommendations to serve all the citizens of this great Commonwealth, but the bottom line is we are all here because we believe children want to be safe. And in Pennsylvania, they deserve to be safe. Pennsylvania has a long history of being a leader in this nation. From a political standpoint, the founding fathers, and we are doing a disservice to our children if we don't recognize that Pennsylvania needs to be a leader when it comes to protecting kids. And that's really the heart of these recommendations. As Jason pointed out, there are two systems here. One is under the Child Protective Services Law, which we refer to as the civil definition of child abuse. And one is what my brothers and the state police and my fellow prosecutors handle under the Crimes Code. What we've tried to do with these recommendations is we've tried to marry those two so that as much as we possibly can, we have consistency. And we're also requiring these two entities to work together. I know that Pennsylvania back in the 90s said we're going to require multidisciplinary teams. Well, guess what? It has to happen. Because as a prosecutor, the cases that are most successful in front of juries are the cases where you can describe to the jury the big picture. And the big picture only comes if that child feels safe, and if that child is well taken care of, and if the system centers around the child. So I'm not going to talk much. The recommendations for the Crimes Code are in your packet, and they're in bullet points, but I did want to point out a couple of things based upon what my fellow members have already talked about. We have heard from prosecutors and from police officers and from children and youth caseworkers that children die. Children die when they are not properly taken care of. These are commonly referred to as general protective services. Dr. Berger said they're GPS cases. So one of our recommendations that we are making is that for those children who are taken away from the society's viewpoint, we've had cases where kids who have been known to children and youth services are removed from school and they are homeschooled, and nobody gets to see them. And when the caseworker shows up at the house, the aunt or uncle answers the door and says, oh, they took the child to the store, or he's not home right now, or he's at a friend's playing. And we have found that those children are dying due to physical abuse. So we've done a couple things. Under the Crimes Code, we've said that endangering the welfare of the child is going to extend to people who live in the home and actively know that a child is being abused and fail to report it. The other thing that we're going to do is make it a crime for those same people, should a children and youth caseworker or a police officer come to the home and they act like the child isn't there. Someone who is not cooperating or failing to do what they can so the child can be detected. But also, when it comes to homeschooling, these children who are at risk, who are known to Child Protective Services, who have either themselves or another child in the home has been the subject of a report within the last 6 months and then all of a sudden are being homeschooled, we're asking that Children and Youth and Family Services now have an obligation to be checking on that child for 6 months and then another 6 months. And if those two risk and safety plans come up okay, then the child is cleared and there's no need for further involvement by Child Protective Services. However, if there is an opportunity to protect those kids and save those children, we want to do that. So those are two things that weren't talked about. The last thing is near and dear to my heart, and it deals with child pornography. We're seeing an epidemic of child pornography in Pennsylvania, and we've heard from the police that they have very difficult times getting very basic information in order to initiate these cases. So we are recommending that the legislature support administrative subpoena powers, which allows the district attorney's office or other prosecutors to go quickly to these entities, obtain very basic information so that they can begin to develop their case. You heard me mention earlier as an amendment, I prosecute a lot of child pornography cases, and you would be amazed at the sentences that are handed down to people who possess these very heinous images of children. We're asking that the Sentencing Commission take a second look at those requirements, those penalties that are imposed. Many times, and if an offender has no prior record and they possess child pornography, they get probation. And one thing that we have learned from the Jerry Sandusky case is that child molesters don't always look like monsters. They look like normal people. And I think sometimes the courts are persuaded by the fact that these people have jobs and families, and the courts don't want to disrupt that. But if you would see these images, they would burn in your brain. These people deserve jail time. We don't know the extent of the impact that those children who are being exploited in those images have. So that's why we believe that stronger penalties are absolutely necessary to protect Pennsylvania's kids. We did have one aspect that we felt we needed to deal with in order to solidify successful prosecutions. We heard from several witnesses that they were often intimidated into not following through with reporting child abuse. And many of them were doctors. Many of them were professionals. They were being intimidated or they were being retaliated against because they had made a report. And so we are also recommending a separate crime for intimidation or retaliation against potential witnesses who report child abuse. And lastly, to balance out all of that, we certainly don't want people falsely reporting child abuse. So we've recommended a separate crime for the false reports of child abuse made to harass or cause someone else harm simply because, and not because it's true. We have very limited resources. We don't need to spend time tracking down cases that are not true. So thank you again for your attention. Mr. Chair has been very self-deprecating, as you can tell, but he's been a wonderful person to work with, and we appreciate all of his leadership skills. Thank you.
Very much. Let me just expand just a bit on the references that have been made to multidisciplinary investigative teams and CACs. Let me just start out with the proposition. It has seemed to me with everything I have learned, and we didn't focus this inquiry on the Sandusky matter, but it keeps unfolding in the news. I firmly believe if there had been a multidisciplinary investigative team in Center County in the late 90s, early 2000s, that you would have heard about Jerry Sandusky then, and not 10 years later, that all of the intervening victims would have been spared, and that particularly if there had also been a CAC, which is the logical outgrowth of a multidisciplinary investigative team, there would have been a conviction of him a long time before there was. Simply put, and the law presently requires this, but in a number of smaller counties it just has not proven to be feasible, or at least hasn't been done. A multidisciplinary investigative team is a group of folks who come together to investigate reports of child abuse. At a minimum, they're going to involve the appropriate police entity, someone from the prosecutor's office, and Children and Youth Services. Very frequently, it will also involve a medical component, whether a nurse or personnel of the local hospital that may be providing, or psychologists who are providing the child some assistance in that regard. May involve a number of other people. The next logical outgrowth of that is to the creation of the ability, which takes the form of a CAC, to conduct impartial, professional forensic interviewing of the child by people who don't have a dog in the fight, who are, in a sense, above that. They're specifically trained in dealing with children of whatever age. They are verbal and able to communicate, in ways that are non-threatening, that are non-suggestive, so that the objective is simply to get at the truth. And, Jackie just referred to the creation of additional penalties for falsely accusing. Down my way where we have a CAC, we have put matters, particularly I can think of a few that have involved domestic situations, into the CAC and come up with absolutely no indication of support for the accusations, and in fact, in some cases, to the contrary, suggestions that those allegations have been created by an adult as opposed to something the child has experienced. So the CAC involves a physical location where the child can be talked to in a non-threatening, hopefully child-friendly environment. But the key is the trained forensic interviewer. Generally speaking, we find the most effective way, I think the consensus is to record these interviews, both audibly and ideally on videotape. And the power of this is enormous. The power of the recordings frequently lead people who have been absolutely adamant, and we've seen it in my county, we've seen it in a lot of places, to plead guilty once they've seen the tape. And the other aspect of both the MDIT and the CIT, or CAC rather, is that people hold each other responsible. These are tough cases for a lot of folks. With all of the oppressive activity with police and both law enforcement and the prosecutor's office, it's easy for these things to sort of fall by the wayside. Having multiple people responsible to each other helps prevent that from happening. I know that this, along with the various things that Ms. Bernard mentioned, are something that's strongly supported by prosecutors throughout the state. And some of the most inspiring testimony I felt we heard was from some of the folks who were making this work. Briefly, to put things, I'm getting the hook by our learned counsel. I'm sure you folks have questions to ask. Let me just say again, we've proposed a system of additional advisory folks to interact with the legislature and the executive branch of government. I believe this is very important because the input we got here, if we hadn't made one recommendation and simply had canned the testimony we got, and it is all available, by the way, over the internet, both audibly and I'm not sure where transcriptions are available, but you can listen to it all, and I hope policymakers, in evaluating what we're doing, what we've proposed, do that. There needs to be an ongoing dialogue. This isn't something that's going to be solved in 6 months. And we have wonderful resources academically in Pennsylvania. Those need to be tapped by policymakers on an ongoing basis. So that will be one of the measures, whether we've been successful, is whether this dialogue is going on a year, year and a half, 2 years, 3 years, 5 years from now. In conclusion, let me recognize Bev Macareth, of course, our Deputy Secretary, the designee of the Secretary of Welfare. Ms. Macareth, the floor is yours.
Thank you, Chairman Heckler. Good afternoon, everyone. I want to start by saying that the Governor and the General Assembly got this right. They put the right people in the right seats around this task force table. The members of this group are people with varied experience and expertise, but what each one of them has in common is that their heart and soul is devoted to the protection of Pennsylvania's children. You are truly an amazing group, and I am honored that I've had the opportunity to be here at the table with each and every one of you. On behalf of Governor Tom Corbett, the the Department of Public Welfare Secretary Gary Alexander, and the Office of Children, Youth, and Families, I want to say thank you to each one of you for your service and your commitment to the children of Pennsylvania. Chairman Heckler, I was going to say something funny, but I told Mary I'll pass on that. A special thank you to you for your leadership. You have never allowed us to waver in our mission. You have kept us focused and moving forward, and you are absolutely the right guy for the job. So when you got that phone call from the governor, thank you for taking on this assignment.
Thank you.
I want to offer a very special thank you that goes out to the tremendous staff from the Department of Public Welfare, Juvenile Court Judges Commission, the Pennsylvania State Police, the Office of General Counsel, House and Senate staffers, and especially the Joint State Government Commission, who really did put up with an awful lot. Without all of you, this work could not have been done. Thank you. I want to end my part of today with one of my favorite quotes, and it's by Margaret Mead. And last night I was just sitting back trying to reflect on the last year. And the last year has been, it's been very rewarding. It's been very time-consuming. And I couldn't have asked for a better way to start my first year as Deputy Secretary for the Office of Children, Youth, and Families. The quote says that, "Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has." My thanks goes out to all of you. Thank you.
And now we will entertain questions. I'll ask that those who have questions, if you haven't been daunted by this onslaught, step up and use the one of the microphones, if you would be so kind. Okay, well, now there must be a question or two. Although, I'll tell you, there is a ton to absorb in attempting to try to convey to those I've spoken with about this in the press what we're proposing. There's a ton. There is a ton of it, and it's going to take some time for people to digest. I can tell you all of it was carefully considered, but be happy to entertain any questions. Ma'am, come on up. Well, I'll defer to others. The fast part, I think the legislature is going to have to sit down and go through that discussion. Certainly, the things that we've picked, sort of the highlights, if you will, in the things we've discussed. Beyond that, members, somebody want to weigh in on that?
I think the points that we collectively brought together today are the ones that can be implemented fairly quickly and fairly inexpensively, and the ones that are more systemic need to be developed in conjunction with the Department of Public Welfare. Things like tracking the General Protective Services cases and the development of child advocacy centers. That's the bricks and mortar where the investigative teams can go to do their work. That takes a little more time. So I suspect that the information that we've talked about today would be the things that are most readily and easily deployed quickly. I'm sorry, Jackie.
Say, at the risk of being facetious, I used to have a boss who would give me a list of things to do, and then I would say to him, okay, well, which ones are priorities? And he would say, all of them. So it's interesting, but right now, I would, if you were to ask me, I would say, and I think this was pointed out by Mary Taylor earlier, one of the things that counties can do right now is to actively use multidisciplinary investigative teams. The people are already in place. They're employed by police agencies. They're employed by Children and Youth Services. That can be done without any more legislative action. So this is recommendations to the legislature for their action, but it's also recommendations to the state of Pennsylvania about how do we change what we've been doing to make it better. We have the tools that are in place. All we have to do is use them. I do think it is critical, however, that those definitional changes are going to need to be made, and appropriate training will have to occur with the caseworkers in the field as well as with police departments, because law enforcement is going to be working very closely with caseworkers to the extent where they're going to have to understand where the jurisdictional limits are for each other and what the objective is for each agency.
I would say that there are some areas that if we don't act, we really are not doing our collective jobs. So, for example, if we don't address the definition of child abuse in the state of Pennsylvania, we will continue to kind of lead the rear, okay? If you look at statistics of child maltreatment in the United States of America, Pennsylvania looks like the kindest, most gentlest state, and it's not, okay? And in part, we don't track what we know to be child maltreatment, and in part, our definitions are in some ways so narrowly defined that what is child abuse in every other state in this country is not necessarily child abuse in Pennsylvania. So, if I think about just changing the definitions of child abuse, that's a start, but without some of the other pieces that my colleagues have addressed, we really don't have a comprehensive improvement plan for the state. So I think that that's probably why Jackie's saying, everything is important, because they're like pieces of a puzzle. So, if you want to change the definition, but you also want to make all the adults who are really responsible and are in positions of responsibility for children, hold them accountable, right? You want to hold the Jerry Sandusky's of the world accountable in your state laws. You want to ensure that when cases are investigated, they're investigated appropriately. So I think all of these things really do work together.
If I were suggesting to the legislature, I'd do it a little bit the other way around. I would take a look at the broad panoply of particularly definitional changes and other substantial changes we propose for the CPSL. And I'd say, are there changes that are going to cost a lot of money or that are going to be very difficult or expensive to implement? Okay, let's take them, let's put them over here and get a timetable, talk to the department, talk to whoever is going to be spending the money, and figure out how we do that. Let's take everything else that, especially the information flow things, the things that get doctors adequate information, the things that at least have us keep track of the fact that kids have been getting this so-called neglect GPS service. Let's get going on that. And certainly CACs and the MDITs are, that is an easy win, not entirely free, but the ones that exist now, every one of them have been privately organized. A number of them, most of them are provided by hospital organizations or medical providers. I think I've got the only one down in Bucks that a victim service organization was the leader in providing, fundraising and getting that together. There's always a certain amount of money that comes, and I'm gesturing here to Bev, that comes through the needs-based budget that the Children and Youth Services in the county supports it. So it's sort of it's a combination already, a little bit more money aimed at having a CAC within 2 hours drive, say, of every child in Pennsylvania. That's concrete and doable, but an awful lot of the rest of this is pretty doable. There's some expensive stuff that you I think can reasonably expect to weed out. Delilah?
My same mantra, prevention, prevention, prevention. And although I'm encouraging our state legislators to put a line item in the budget for the prevention of child child abuse, however they want to do that. But I would say to everyone here, it can start now and it doesn't cost anything. Every individual here has a responsibility to protect our children. Everybody here can go back to their workplace, go back to their community, city councils, county commissioners. Every community has some sort of function where people come together and talk about the services needed in their communities. So every one of us can leave here today with a mission to put together a plan for the prevention of child abuse in our communities.
I was going to make a comment that I think that all of what we've said today is what we'd like to see as a culture change. And truly that this, as a culture, ideally in the whole country, but specifically in Pennsylvania, where children come first and child abuse prevention, whether it's primary, secondary, tertiary, in any form, is part of that culture. And I think, I said, having been in Canada many times, everybody there is a mandated reporter. And everybody feels like child abuse is their responsibility. And it's a culture. And it's very hard to explain what a culture is, but we don't have it. And we see it in our everyday lives where people will say to me, oh, you have 3 child abuse physicians in Western Pennsylvania? You need 3? We could have 12 and we wouldn't have enough. People have no sense because of all the stigma of all the only thing we ever hear about CPS is bad, right? And the only time it's ever in the press is when it's negative. And so I think as a culture, we need to change. And so all these things, little by little, change a culture, but no one of them is going to do it by itself.
Okay. Number one, and actually I addressed those two very briefly in the report. Ombudsman, most of the states that we're aware of that have such an office have a centralized children and youth services literally out of the state capital. So if somebody is dealing with your child in your home, they report to Harrisburg. We have a centrally funded, locally administered child protection system so that the person who's dealing with you and your child in your home is from, the county seat. As a judge, I dealt with at least one case where there'd been already a declaration of dependency. I felt a county commissioner was inappropriately getting involved in the system. Certainly, there was no shortage of local people that an aggrieved party, whether somebody who thought a child wasn't being adequately protected or somebody who thought that the child protection services shouldn't be offered or the decisions were wrong, that's all available locally. Adding another layer of bureaucracy in a state this size in Harrisburg, it just isn't relevant to our system, at least in our view. Statute of limitations, we go over it in the materials. I'm going to say now, for prosecution, you're talking a child right now who would be abused. We can prosecute up to the time that child is 50. I don't know how you do that, frankly. I think it's illusory, but you can't extend for those. For criminal, it's definitely ex post facto. Once you, as a child abuser, have waited out the statute of limitations and it's run, you're done. We can't extend the statute and create windows. Can't be done under the prohibition against ex post facto criminalization of conduct. I don't believe it has. I do not believe it has. We've increased the window. And if the statute hasn't already run, that's fine. Then it gets longer. But my understanding of the law, well, it's 50 for criminal. It's 50, and my understanding of the law is that it's well settled. It's ex post facto with regard to criminal prosecutions. Once the statute's run, it's run. I'm not as sure about civil. Our charge, however, is to deal with the protection of children. The issue of whether somebody who's now 35 or 40 should or shouldn't be able to sue somebody is simply not our, and frankly, I can't tell you how crazy it makes me that that's the idea that pops up with all of the stuff that needs to be done to protect kids, to create the ability for a certain group of people who, you know, maybe had horrible things done to them, maybe they can't. How we're even going to figure that out 30 years later, except guilt by association, I have no idea, but it's not our ballgame. So others may opine on it, and the legislature will deal with it or they won't. It wasn't something that we felt was in our wheelhouse. I believe there's, yes, ma'am, thank you. Good.
Yeah, my question is for Mr. Koudalakis. You mentioned the Penn State situation and the reporting up the chain. What you're proposing, I want to be clear on, is that there would be no more reporting up the chain. People would have to go directly to Childline in a situation like that?
Actually, there's redundancy in that system. The person that first comes to have the information that is required to report is defined. That person shall call directly him or herself and contemporaneously report that up the chain of command.
So in the Penn State situation, if what you're proposing here had been in place, who would have been required to call Childline? Would that Mike McQuarrie would have been required to call?
Janitor, Mike McQuarrie, that first person would have had to call directly himself and report it up through. I mean, there's some federal legislation, the Clery Act and things like that require educational institutions to conduct investigations. They have internal reporting processes. We're not messing with that. What we've done is say, for redundancy purposes, to make sure we don't have something falling through the cracks again, that we have that redundancy. That first person has to make the direct report.
Clear, we add colleges, make it clear that that whole business related to schools, we got rid of schools altogether as a separate category. So everybody who's an educator under our proposal stands just the same as a doctor or anybody else. You see child abuse, you have reason to suspect child abuse, you have an obligation to report, and we make it clear that colleges who are dealing with people under 18 have the same obligation. Other questions? You've had all you can stand. Well, we hope you will read all of this carefully. We'll be happy to entertain inquiries over time. Thank you very much for being here.